So good morning. My name is JC Cortez. I'm the Director of Training and Development here at Synergia's Metropolitan Parent Center. A few words on Synergia. Synergia is a multi-service agency. We're located in Manhattan in East Harlem that's been supporting New Yorkers with disabilities and their families for more than 40 years. We offer a rich source of information and training tailored for parents, including parents whose primary language is not English or who they themselves have special training needs. We help them participate more effectively in their children's presentation and development. And we partner with professionals and policymakers like we have today to improve outcomes for all children with all disabilities. Synergia, which is Spanish for synergy, is one of New York City's 3 federally funded parent centers committed to serving people with disabilities and their families with an added focus on communities of color and the economically disadvantaged. Synergia creates innovative programs ranging from transitional housing for homeless families to community residence for adults with developmental disabilities, and also parenting and education advocacy training for parents of children with disabilities. So before we get started, I want to introduce one of my favorite colleagues, Ms. Paola Martinez-Boone. She's a very knowledgeable resource who has been working across New York City for over 20 years, maybe even more actually, in this field and supporting families in different roles in different organizations, but she's an incredible resource and we're so lucky to have you today. Welcome back to Synergia, Paola. And yes, let's talk about future planning because, you know, we talked about transition to adulthood here at Synergia last week and, you know, how you can prepare that, but we were focusing so much on the IEP, right? And what that looks like and what needs to be included for transition, you know, those last evaluations, those last exit summaries, you know, and like how to also think, you know, outside the scope of high school, you know, like what else is out there, you know, because there's vocational training, maybe adult education, maybe just independent living. But this is going to like complete that scope because now we're going to talk about other aspects of life, you know, legal instruments that you're going to need to have or should be thinking about, right? What does that future look like in supporting your young one as they become a budding adult? So yes, so welcome back and thank you.
Thank you, JC. Good morning, everyone. It's my pleasure always collaborate with Synergia. We have been working together for many, many, many years. My name is Paola Martinez-Boone. I'm a senior advocate and special education coordinator at the New York Lawyers for the Public Interest. New York Lawyers for the Public Interest is a nonprofit legal organization, and we do take individual cases, and eventually when we see issues with systems, we also take on systematic cases. If you need help, if you need legal help, you have a legal issue and need legal help, you can call our main number. It's on the screen, 212-244-4664. Or if you don't want to talk to anyone at the moment or you don't have time, what you can do is just to click on the link that says NYLPI.org/get-help, and they will ask you 3 simple questions: your name, your telephone number, of course, because we need to be able to reach you, and why you're contacting us about. What is your legal issue? Now, keep in mind that we are a legal office and we only attend to legal issues, and we don't take every single case. We're only able to take cases that fall into our area of practice. Let's see. Okay. Once again, I want to remind everyone that this PowerPoint, I'm happy to share it. And you can share it to other people, families, parents. Is important information, but you have to share in the same format that you are getting it. You cannot change anything about this PowerPoint because it's our, PowerPoints, New York Lawyers PowerPoint. So you cannot change anything. We are, it's our license is out. Is ours. I cannot stress anymore this. My supervisor gets me on this all the time. Okay, I have a lot of information about New York Lawyers. Our areas of practice is a civil rights organization, nonprofit legal organization. We focus on disability. That's the program that I work under, disability rights. We've been doing this work for almost 50 years. So it's been a long time. helping New Yorkers with disabilities, but we also have other programs. We have a health justice program, environmental justice program. We also have a policy piece. So I will encourage you, if you are interested in learning more about New York lawyers, just go to our website and see what we have done in the past, what we're working on currently. And we're always happy to take on a new cases, meaning that sometimes we have this area of practice and we have done a lot in certain areas. However, something new comes and we are able to analyze it and say, you know what, this is something that we want to work on as well. I'm not going to talk more about New York lawyers. Once again, it's here. If you get the PowerPoint, you can read it, or you can go to our website. I want to go right into the presentation today, which is planning for the future when you have a child with disabilities. And why planning? That's the first thing. Why planning? Well, one is preserving government benefits. For many of you, you know already that your child is depending on Social Security and Medicaid. And sometimes we have to think about how to preserve those benefits. And I'm gonna explain to you why this is so important, because sometimes parents don't know the right way to plan. They actually end that in public benefits eligibility. So I'm gonna talk to you about how not to do that, how to make sure that you're improving the quality of life of your loved one with disabilities, but also you can benefit from public benefits at the same time. Also to expand and not to limit choice. Sometimes people think that because you are the parent or the loved one of a person with disabilities, the only choice that that person have is public benefits and no more. And that's not correct. You can actually expand and limit it instead of limited choices for your loved one with disabilities if you know how to plan correctly. And we're gonna talk about that today. Okay, first we start by thinking about the person's needs, their medical needs, the behavioral needs, social, emotional, and all that. If the person already is have a care coordinator, have a life plan already, a lot of this have been discussed already through the life plan. And I encourage everyone to be active and to be participating in your child's life plan, because most of the time, my experience have been that parents don't even read their life plan and they don't know what is there. It's important for you to understand the same way that you if your child's in school, you want to see what is on the IEP. You also want to see and get yourself a lot of information on what is on your life plan, and also talk to the care coordinator about what is working and what is not, because that's the other part. Parents don't pay attention a lot of times to the life plan, and then the child is enrolling these things that they're not benefiting from because it's not the correct life plan. So, you know, getting acclimated with a life plan so you can also add to it. Possible actions: do nothing and hope for the best, and relying on government benefits only. Please don't be one of those parents that said, I'm gonna leave, whatever happens, happens. I'm not gonna do anything. I'm gonna, and I know it could be an anxiety provoking planning, because when you plan, you look ahead and you look at your child with disabilities, knowing that he's gonna grow up and you also gonna grow older. And sometimes there is an anxiety that comes with that. But let me tell you, I have received so many calls throughout my years of experience from family members of a person with disability that they don't know what to do with this person with disabilities, because there was no planning on the part of the family. There was no planning on the part of the parents. There was no planning on the part of the caregivers to put things in place for this loved one with disabilities. Now we're still in a pandemic, and through the pandemic, we lost a lot of people, and some of those individuals were parents of people with disabilities. And during the pandemic, I was getting those calls, and it breaks my heart, because there is so much that you can do ahead of time to put things in place in order to make sure that you love one with disabilities cared for, and at least someone or several people in your community and your family, in your environment, knows what to do and how to assist. Think about what you have also. And this is huge because a lot of people tell me, oh, I don't have anything, I don't have to worry about it. And then I start digging a little bit. I say, do you work? Yeah, I have a job. I work for government. Okay, if you work for government, that means that you probably have a pension. If you, what else do you, oh, they also give me an insurance. Well, that means that you have an insurance. And, a lot of things start coming up. And then I say, well, if you have a pension, if you have insurance, guess what happened? Who's your beneficiary? Oh, my child with disabilities because he's going to need it. Okay, guess what happened if your child gets your pension and your life insurance? He's not going to be eligible for public benefits. So you can have all those things, but you have to put them in the right place in order for your child to benefit from that while it's still eligible for public benefits. And that's the takeaway from this. And we're not talking more about this, where to put those monies in order for your child to really benefit from your pension plan, 401k, 403b, if you own a house, if you own a business, if you have shares, stocks, bonds, I-bonds through the Treasury Department, whatever you have that you are thinking, or you already put the name. And this is really critical here, because sometimes when we get a new job, and a lot of people have transitions through COVID, they give you a whole bunch of papers to sign. And sometimes you put your child's name in every paper and then not realizing that this really could impact your child's benefits and your child's life if you don't do it correctly. So here I'm showing you what I'm going to talk about today. Letter of intent, financial planning, supplemental needs, all those things I'm going to discuss with you. Please ask questions. There is a Q&A button there. Put your questions there. I'm going to address all your questions, and the ones that we don't have time for it, I always provide my email and my contact information, and I'm pretty good about responding to individuals. Now, I want to stress everyone, we are live streaming to Facebook, and this is a public forum. I don't want personal information questions because I don't want your information to be out there. This is very, very important. This should be confidential and private. If you have a specific case, if this triggers something in you and you say, you know what, I have personal information that I need to discuss with Paola, I'm happy you email me and I could coordinate a time to dedicate it just to you and your questions and your concerns. 15, 20, 30 minutes, and that way you don't have to air anything here in this public forum. So I'd rather have that general information about what you're learning here today. Of course, if you don't understand something that I'm saying or explaining, please ask, because this is about you. I know the information, but I want you to know you to learn the information. Okay, so let's start with the letter of intent. And letter of intent is not a legal document, but really what it is a map that will describe needs, wants and needs of your child. And think about the letter of intent as a resource in which you're going to share with people, family members, friends, family, in case of an emergency, they be able to help you with your child for a day, for two, for a week, while somebody else come to help. And this is the purpose of the letter of intent. You will write there, the school that your child attends, at what time the bus comes, medication, doctors, anything that you believe is important. Even if you want your child to be taken to church every Sunday, if that is so important to you, you write it in a letter of intent. It's not a legal document. And I want to be clear about that. It's not a legal document, but it's a map that you provide to other people to be able to help you with your child. Because think about this. If you get sick of anything, and sometimes we go to the doctor thinking it's something minor, it could be something major, and the doctor is like, you need to go to the emergency room. So if you don't have anyone that knows what to do with your child, while you are stressing about your own illness, you're also stressing about who's going to care for my child. If your child has autism, for example, and you know he or she likes routines because that's part of what autism does, and nobody knows that routine, there's a few people that are going to be able to handle that, and you don't want to stress anyone else. So what do? You plan. I know many of us are not planners. I understand that. But when you have a child with disabilities, sometimes we are forced to do things that we are not used to do before. And planning is one of them. Letter of intent will do that. It will map out a day of the life of Johnny or Peter or Amanda, that it could serve as a guide to somebody else that wants to help you. And I'm gonna give you an example. If I'm your next door neighbor and I know you have a child with disabilities, I have a child with disabilities too, I want to help you because we're in the same community. But if I don't know anything about your child's routines, medications, your child's, where he goes to school, where I'm supposed to be picking up, where I'm supposed to go, how am I gonna be able to help you? I'm not gonna be able to help you. So we need to think about that. Planning is that, kind of looking forward and see how can I make this situation better. Okay, in terms of planning also, we also have to understand what this comes from. And this comes really from the definition of capacity. How much capacity our loved one with disabilities have. And many of us don't know. Many of us just, when they were little, they told us, oh, your child needs to go to early intervention. And from early intervention, they're going to go up pre-K 3, 4, kindergarten, turning 5, and this and that and the other, and we're rolling with the punches. But nobody talks about what's the capacity of the child with disabilities. And we need to learn that in order to know how much help that person needs, or how little help they need, or how much support. So understanding capacity is key. So under the New York State law, everyone who is 18 is presumed to have decision-making capacity. This always comes as a shock for parents of individuals with disabilities, because they tell me, oh, my child doesn't know how to do anything. My child is 18, but his mind is like a 5-year-old. Well, the law still applies. Under the New York State law, everyone who is 18 is presumed to have decision-making capacity. Who is an incapacitated person? A person who is impaired by reason of mental illness or mental deficiency to the extent that he or she lacks sufficient capacity to manage his or her affairs. So now we understand, if somebody told you your child is 18, but cognitively they are 5-6 years old, they are an incapacitated person. Now we clarify that. Who is a guardian? A guardian is a person who been appointed by the court to make decisions on behalf of a minor or an incapacitated person. Now, you are the guardian of your child with disabilities if your child is a minor. Every parent who is in care of a child with disabilities is parent and legal guardian. Now, if you went to family court because you divorced and blah, 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 there are papers there that they probably provided you that said you are the guardian. Or if you are an aunt who is raising somebody else's child and you went to family court, then you became the legal guardian that way. Now, when your child turns 18, that's a different type of guardianship. I want to clarify that. When your child is 18, meaning that the child is already an adult, and under the New York State law, he is presumed or she is presumed to have the decision-making capacity, then that's a different type of guardianship that you need to look into, and we're going to learn about that if that person doesn't have capacity. There are other tools as well. We have the surrogate decision maker. So any individual who is authorized by law, once again, by law, or who is in fact making decisions for another. And then we have the Family Healthcare Decision Act, and this is what OPWDD has followed for years, provides a process for a surrogate decision maker to make end-of-life decisions on behalf of someone who lacks capacity. So once again, how do we know if our loved one have capacity? Well, if you're not clear, you have to have a conversation with the people who are actually working with your child, psychologists, doctors, neurologists, all those individuals who actually have evaluated your child. They really have a good idea that what capacity your child have or your loved one with disabilities have. How we evaluate decision making. Explore decisions individual has made or is facing. Sometimes what you will know that by asking the individual questions, and then by their answer, you kind of gather this person doesn't really have capacity. However, I wouldn't just follow this to identify someone with capacity or lack of thereof. Once again, rely on evaluators. This number 2 for me is the most important, is balancing respect for individual self-determination and protection of his or her well-being. And this is a challenge for parents and family members. Sometimes I get in both ends of the spectrums. Parents tell me, oh, he doesn't know anything, I need to do everything. And then I say, let me talk to your loved one with disabilities. And then by talking to that person, they could make some decisions, and the parent already is dismissing that person. So we have to be careful about that. Or on the other hand, he knows everything, he understands everything, he's able to make decisions. And then when I speak to the individual, it's like this person lacks capacity, because whatever answer he's providing me is not in tune with the questions that I'm asking. So once again, we don't want to be in any far of the spectrums. We want to be realistic about what's going on with our loved one's capacity, because that's going to inform us how to support that person. And that's what we want to do. A person may be competent in one area and not competent in another. For example, a lot of people with disabilities, and you will hear this from the self-advocates, they are capable to do and speak for themselves in many, many issues. But there are some times, for example, when it comes like a very important medical decision, they will need support, or legal decisions, they will need support. So we need to also identify what areas can I jump in and what areas are good. Will let that individual to be an independent person and make decisions on their own. That's very important for the self-esteem. And that's the other part that parents, I know we all want to protect our loved one with disabilities from harm, but also there is something called self-esteem, self-determination that is taken away when we always speaking on their behalf, when we know they have capacity to make some decisions. For example, what programs they want to participate. I see it all the time. The parents like, oh, I want this program. And the child is like, I'm bored there. I don't want that program. I want this other program. And the parent is doing something else. So once again, we need to be mindful of this. Once again, components of decision-making capacity, ability to communicate a choice, ability to understand relevant information, and ability to appreciate the nature of a situation and the likely consequences. This is an important one. It's not only about decision making, but it's also understanding the consequences of those decisions. This is the domains in which most of us make decisions every day: living arrangements, social activities, work, trainings, all these have to do with decision making domains. Okay. So now we're going to go to the financial part of the how planning for the future. So at first I want to explain a regular trust. So a regular trust is an instrument in which you can put cash, stocks, bonds, property in order to benefit somebody else. So for example, if I'm a parent of 3 kids and I have a pension plan, or I have inheritance, or I have money, I won the lotto, then $1 billion that I was playing during the summer, I want to create a trust for my kids. So I will be, because it's my money, I won the lotto, I will be the grantor. I'll be the person who is giving the money for that trust. The trustee is the manager. So because I won the lottery, and I know this sounds far because I'm talking about the lottery, but I'm gonna come back and say, let's say just it's a pension plan. It's a pension plan, but I work for the same place for 25 years, and I have, for example, I work for AT&T or Verizon. I have a pretty good pension plan. So I put in this money in a trust for my kids. So I'm the grantor, and then the trustee is the manager of that money. Now, why do I need a trustee? Because sometimes I just want to be the person who funds the trust and somebody else could manage it. An attorney, somebody else, I don't want to deal with that. And then it's the beneficiary. The beneficiary is the person who's going to obtain this money. So this is a regular trust. This is how people leave money for other individuals, especially when you have minor children. Most people will do this. We'll do a will, and with the will, it will be a trust together with a will, and then that's how they're going to divide their funds. If something happens to me, I'm young and strong, but my kids are underage, so I want them to have a trust. And then I give them the money for the trust. I'm the grantor, the trustee is the manager, and my kids are the beneficiaries. So then what happened when you have a child with disabilities? What happened when you have a child with disabilities, there's something called public benefits. Medicaid, which pays for everything, all the services in the adult services specifically, and we have Social Security. So how do I leave money for my loved one with disabilities if I know that they need Medicaid? Now, eligibility for Medicaid is $14,500 a year. So if your loved one with disabilities have more than that, they're not going to be eligible for Medicaid. So what comes into mind here? Supplemental needs trust. Supplemental needs trust is a special type of trust that the purpose is to preserve public benefits, meaning you could still have a pension plan, you could still have money that you're going to leave behind for your loved one with disabilities without interfering with their public benefits. And that is the sole purpose of a supplemental needs trust or special needs trust. Now, 2 things that you need to learn about the trust. It's irrevocable, meaning you cannot change it at all. Once you find an attorney, they draft the trust is probated, then you cannot change it. It's also discretionary, meaning that the trustee have the authority to make or refuse, and people don't think about this at any time, or refuse distributions, meaning that you are authorizing that trustee to manage the trust whichever way they see fit. And they could deny also providing money. There are different types of trusts. We have the first party trust and we have the third party trust. And I'm gonna explain that. The first party trust is also called self-settled. And it means it's funded by money of the person with disabilities. Now, a lot of people ask me how my loved one with disabilities is gonna get money. Lawsuits. If your child, something happened to your child and you are in court right now and there may be money coming his way, that is the way that people with disabilities will fund self-settled trust or first party trust. And it's important for you to know this information because guess what? A lot of people, especially parents of people with disabilities, go to court, they sue someone because medical malpractice or an accident or something, and because they have a child with disabilities, they think that the money is gonna go straight to them. It doesn't. It never does, because the court wants to protect that money from everyone, including parents. So what do you need to do in this process? You need to make sure that that attorney that you recruited or hired to help you with the lawsuit establishes a first party trust for your loved one with disabilities. So whatever money he gets, $20, $50, $100,000, $1 million goes into that trust. Because if you don't do that, you are at risk that the person with disabilities is not going to be eligible for public benefits anymore until they spend that money, or the court will assign a guardian of the property through the court, and that I don't suggest for anyone to have. So once again, if you don't remember anything, Just remember that if you're suing someone on behalf of your child with disabilities, adult or child with disabilities, that money never gonna comes to you. And you need to educate in case that the attorney that you hire doesn't know that your child depends on public benefits such as Medicaid, that they need to establish a first party trust before they settle the case. So that way the public benefits are protected. Then we have the third party trust, which is the trust that parents, grandparents, family members, friends of the person with disabilities will create to benefit that person. Once again, the person who provides the money is the grantor. The trustee could be anyone that you pick, or it could be yourself. If it's your own child and you want in the beginning to be your own trustee, you can do that as well to benefit the person with disabilities. Once again, the rules apply. It's irrevocable. Once you establish a third-party trust, it's irrevocable. You cannot change it. And it's discretionary, meaning that whoever, if you're not the trustee and you assign somebody else as the trustee, that person have full authority to distribute the money or not. And I have seen this recently with someone who have an attorney as a trustee, and the person with disabilities needed money to establish something. I don't remember what it was right now. And the attorney said, no, I'm not giving money from the trust for that. And it was something that this person really needed. And the attorney said, no. So once again, keep in mind that the trustee have full legal power to refuse to disperse funds. I give you also a link to guidelines for the administration of a supplemental needs trust, so that way you also learn a little bit more about supplemental needs trust. Pool trust is usually mainly seen in nonprofits that want to keep the person with disabilities until the guidelines, so they don't, whatever money doesn't pass the eligibility for Medicaid. Some nonprofits have it, others don't. So if you're interested in this, you probably could ask the nonprofits about it. Then we have another tool that you can put money aside. This is easier than supplemental needs trust. You don't need an attorney. You don't need anything. This is the ABLE account, 529 ABLE account. And this is another tool that you can use to put money aside. You can put up to $15,000 a year, including the person with disabilities. If you have a person with disabilities who actually works and they want to put money aside, this is a way to put money aside for that individual. And also, or you as a parent, grandparent could put money aside. Is secure money. Is managed by the comptroller's office in New York State, and you can call them, and they have pages and pages of about information about the 529 ABLE account. Is underutilized, by the way. There are a lot of people who should be benefiting from this, but they are not. Also, another key point here is that if your child, when your child was little and you open a college account, which is called the 529 account, and now you realize that your child is not going to be able to use it because they're not going to college, you can actually transfer that money from the 529 college account to the 529 ABLE account. So once again, a lot of information at the controller's office, and I have the link to their information as well. Okay, so now we're gonna talk about decision making and the auctions that exist. We have the least restrictive auctions, which is the person making their own decisions. That's ideal when applies. Then we have the healthcare proxy, we have the power of attorney, and we have supported decision making. Now, on the other hand, we have the more restrictive auctions, which is guardianship, surrogate decision making, and the Family Healthcare Act, which I spoke about in the beginning. Let's start with the healthcare proxy. The healthcare proxy is an amazing tool. We should all, disability or not, have one, because the healthcare proxy allows an individual to name a healthcare agent who will make a decision if an individual cannot make them on his or her own. This requires capacity. Once again, this requires capacity, but once again, we have a lot of people with disability who they have disabilities, but they still have capacity, because that person have to make a conscious decision to assign someone as their agent. Now, the beauty also of the healthcare proxy is that that agent immediately doesn't start making decisions. That agent, in the case of medical procedures and you are in a coma or you are unconscious, you will need 2 doctors to decide that that person no longer have, the patient no longer have decision-making capacity. So there is a protection there. So even if you assign an agent, you have to have a protection that said, well, I know you have an agent, but there are 2 other doctors that need to also agree that the patient doesn't have capacity, and therefore the agent now is capable to make those decisions. So it's very, very, very important tool, very good tool. But what is important here is the person with disabilities, if you are doing that for your child, must have capacity. So don't be confused, because I get those calls, oh, my child needs a guardian, and I'm gonna do guardianship, but in the meantime, let me ask him to sign a healthcare proxy. Those things don't go together. If you're telling me your child doesn't have capacity, then he or she cannot sign a healthcare proxy. So just clarifying the very, very important tool. Then we have another tool for finances, for to manage, financial decisions, which is the power of attorney. And the power of attorney, once again, the individual must have capacity in order to assign an agent. Now, a few things changed in 2020 for the power of attorney, and now we have 2 types of power of attorney. One is the springing power of attorney, that you're still gonna name an agent in advance, but that person doesn't have any authority until the client becomes incapacitated. So it's like it's a planning tool. Okay, if something happens to me, I know I already have an agent in place that will take over if something happens to me. However, there's still the dual power of attorney, which is the traditional one, in which you name an agent and the agent becomes effective immediately. As soon as you sign, that agent could make decisions, financial decisions on your behalf. Once again, key here for family members and parents, grandparents, the person must have capacity in order to assign an agent. But this is a very important tool that a lot of people with disabilities could benefit from. If you want more information, there is the link there for you to learn a little bit more detail about power of attorney if it's something that you think that your child will benefit from. Then we have less restrictive, which is supported decision-making, that is designed to assist an individual with disabilities to make and communicate to others decisions about their life. So now, very interesting about supported decision-making is that there in New York State, there are other states that have already established supported decision-making. New York State started a pilot program 6 years ago, in which, and this is a process in which they have a person working with the family who will visit the family and draft what they learn about the individual with disabilities and what areas they're able to verbalize their decisions and understand the consequences and all that. So it's a process. And then at the end, they draft this plan. So it was a pilot program. However, in March of this year, it was passed at the Senate, I believe. It was passed. So my sense is like eventually it's gonna become law, meaning that even though I still have to have it here, that is not a legally binding agreement, because it's not a legally binding agreement, eventually it will become a legally binding agreement because it's already passed the votes. And actually OPWDD was very involved in this because they realized maybe this is a tool that we could utilize in order to assist people with disabilities. So I'm excited about this because this is less restrictive than guardianship. It will benefit because, once again, we have individuals in both of the spectrums. I have individuals that for sure they need guardians, and I have others that are in this middle, that they need a lot of support, and they need a lot of support from family members. They don't want people to speak for them, but once they have a supported decision-making agreement, then they will say, well, I could do a lot of stuff on my own, but for these particular decisions, I have my mother, my grandmother, my aunt to support me. So I'm very excited about supported decision-making to become a law, because it's gonna benefit a lot of our individuals with disabilities. I also have here videos about the supported decision making and the link to the supported decision making group, so you can learn a little bit more about it and see if this is a good fit for your loved one with disabilities. Then we have them moving to the more restrictive, which is surrogate decision making committee, which is important to understand and know, because if you don't have anything, if you have an individual with disabilities who's not able or doesn't have the capacity to verbalize what they need, and then something happens to them, and by the way, hospitals, doctors, they're going to take care of your child with disabilities, capacity or not, because they're there to save lives. However, when there are treatments that are less invasive, but they will need signatures, they will need someone to agree to those treatments, then when it comes about the question like who is the guardian, because once the doctors realize that this person doesn't have a full capacity to understand procedures, medical procedures, they're going to ask who's the guardian, and then you're going to say, I'm the parent, and they say, okay, thank you for the excellent job with this person with disabilities, but who is legally responsible for signing? And then you will be like, oh, I didn't know that. So don't panic, because there is something called surrogate decision making. And what happened is that there is paperwork that they will fill out at the hospital or doctor's office. They will send it to the surrogate decision making committee. They will read it and they will give you an answer approving the treatment or not. And once again, this is not life-threatening issues. For if your child needs an emergency surgery, he or she will have an emergency surgery. This is more, and I'm gonna give you a real example. I have once a grandmother that her granddaughter needed some extractions, like teeth extractions, and the dentist is like, who's gonna sign for this, because I need to put her to sleep, and the grandmother didn't have anything, so she panicked, obviously, and they said, well, we're gonna give her medication for the pain now, but let's fill out this surrogate decision making request and wait for that. So that's how they handle that. Okay, so just another tool that is important for you to know. I already spoke about this. And then guardianship. So once again, a guardian is someone appointed by the court, and I cannot stress this more, by the court to make decisions on behalf of somebody else. A guardian could be appointed to make financial decisions, known as a guardian of the property. However, I want to stop here. I said, if your child doesn't have anything, there is no reason for you to apply for guardianship of the property, because this is not about the Social Security check. This is about property. Now, if like I explained earlier, if you're leaving something behind for your child, a pension plan, you have a life insurance, and he or she is the beneficiary, you have a business, you have a house that you want to leave for your child, all that will go into the supplemental needs trust or special needs trust. So there is no need of guardianship of the property. Be clear, please. And then we have a personal guardianship, which is a guardianship of the person in which you will make decisions on behalf of that person. And there's guardianship for both. Those are your options. Now, the guardianship for individuals with intellectual disabilities and or developmental disabilities is Article 17A guardianship. It's a very specific guardianship. And luckily for all of us in New York State, it doesn't require an attorney. It's paperwork. You need to fill out the petition. You don't need an appointment to submit the petition. And there are forms that live online, and I could send you all those forms. I'll do it all the time. There is also a do-it-yourself guidance. There is also a glossary of terms. So you have a lot of resources. And we at New York Lawyers, we help the court to put together these resources. So I know they exist. And you have to fill out the paperwork and bring it to court. I know because it's a legal document, sometimes people get overwhelmed and scared. Please don't be. It's paperwork. I have people that don't even speak English. They have gone to the court 2, 3, 4 times, and they have rejected the papers. They have pointed out what is wrong with the paperwork. They fix it, they go back until the guardianship documents are filed. So once again, no need of an attorney because there is no need of any arguments. Why would you pay someone to do this paperwork when you're not arguing anything? What you're saying is, I have a child who is an incapacitated person. Here's the paperwork. The paperwork also have one doctor or 2 doctors filling out their own affidavits, their own statement saying, yes, this person doesn't have capacity. And they're gonna also ask you to provide other documents in support that your child doesn't have capacity, and that's all that you have to do. So I understand the anxieties of filling up legal paperwork. And if you have the means and you want to pay $2,000 to $3,000 for someone to do it, go for it. But for most of the people that I serve, they don't have that type of money, so they have to do it on their own. It's doable. I have seen people doing for years and years. So don't worry about it.
Yeah, and I just want to add to what you were saying and piggyback on that, Paula, is that, like here at Synergia, I mean, there's not one week, and I'm sure it's the same at New York Lawyers, where we don't get a request or some sort of ask to help with guardianship papers. And the one thing that you'll find across New York City and most of New York State is that there are just not that many organizations that offer that type of assistance, because the paperwork is very self-explanatory. It's very straightforward. Like Paula was saying, there is no argument that needs to be made. I mean, you're basically just putting a lot of repetition on a lot of papers. And because of that repetition and because of how long those papers are, it does seem like it's very challenging, but it is very straightforward. And the one thing, like if you go to the surrogate court's website, they have an online helper that is kind of like a chat program that's automatically prompting you what you need to put in this blank, what you need to put on the next blank. It might take a while, but that's okay. And the last thing, like Paula said, just take it to the court. Don't be afraid. Take it to the court, because you know what? The first person who's going to read it is going to be the clerk. And the clerk is going to look at it and they're going to be like, oh, you missed a spot. Oh, you need to do this. And the clerks are really helpful. So don't be intimidated by the process. If you do still insist on having somebody consult with to fill this out, yes, you can go the expensive option and go through an attorney. There are a few organizations, very few in New York City, that offer something. I think there are a couple in Brooklyn that only do it for Brooklyn residents. And the biggest person that helps is AHRC. However, I will caution you, AHRC, while they do this service, because the demand is so high, they have a 2-year waiting list. So, you want to get this done before your child turns 18 to just have a smoother transition. So if you're going to start thinking about guardianship, if you really want the assistance of somebody else like AHRC to help you, you need to start thinking about this like at age 15, and that's hoping that the list goes, according to plan. You never can tell. So just some things for you to keep in mind when it comes to guardianship. Yes. And, like Paula was saying, and I can't underscore what she was saying enough, is that, there are individuals that do have the ability to make decisions for themselves. And it's incumbent upon us as parents and caregivers to make sure that we're providing them with the best and most appropriate option. Because the one thing is, when you do guardianship, you take away a person's all of their rights. Whereas like supported decision making or the other options, there are different levels of what you're trying to do and how much support you're trying to offer. So just something to consider, because the last thing you want is to have your loved one in a frustrating situation where then it becomes an issue between them and the guardian. And then it's like, that's just no fun for anybody. Oh, they're going to do this and I don't want them to do that. Oh, they're going to, it's just like, and it's just a back and forth that you just want to try and like avoid. But, we also want to make sure that they're protected and taken care of. So we understand, where you're coming from, but just keep that in mind when you are evaluating these options, because it's really important.
Thank you. That was a great also expansion of what I was saying. So there is a lot that you need to keep in mind, but once again, this is another tool that exists for those of you who are clear that your child needs a guardian because of their severity of their disability or disabilities. This is an option. The other part that I need to add is that you don't need to do the paperwork in one sitting. You can, save the paperwork to your computer and then take another step the next day as you please until you have all the paperwork completed, and not every form that you will receive applies to your situation. So keep that in mind as well. It's not one form, it's a series of forms. For most people, not all of them apply. A question that also is that, something that I want to suggest as well is that once you file the paperwork, keep in a safe place the file number, because when you call the court to ask how my process is going and my name is Maria, there is a million Marias. They don't gonna follow that. They're gonna ask you for the file number. That's what they're looking for in order to give you accurate information about how your case is going. Also, if you move, you need to go to the court and fill out the paper for change of address, because they're going to send you stuff to the old address. And if you need to sign something, or there's a question that they have, or it's even the court day that you're supposed to have and you don't show up because you move, it is on you. So once again, any changes in terms of telephone number, contacts, and especially address, you need to go to the court and change it, because what they're going to, if they have questions for you, or they need more documentation and they cannot find you, they're just gonna close your case. And then when you wait a year and you ask and call, they say your case is closed and you have to start over. So very, very important. That happens in the past, and I want that to happen to you. Also, another key information is for this type of guardianship allows you for one guardian or co-guardians, meaning two individuals. And those two individuals could be anyone. It could be you and your sister, you and your husband, you and, whomever. It doesn't matter today. What is important about co-guardianship is that you both need to agree on every single decision. And that is the challenge here. That is the challenge here, because if you have one parent who travels and their trips at work and you're not able to find them and you need a signature, nothing moves forward until that person signs. And I personally know about that because my husband travels, and sometimes I can even get in contact with him for a day or two. So depending on the country that he's going to. So once again, something to keep in mind for co-guardianships. Now there is other spaces. This is standby, first and second alternative. And the standby guardian is the second in command, but that person doesn't do anything until the guardian or guardian pass or become incapacitated. So keep in mind that let's say if it's the same situation, a husband or a partner who travels, that person could be a standby guardian, meaning that person is not gonna need us to sign anything until something happens to you. So that's something to consider. Now, if you have more family members that you want to add to the mix, you can put a first alternative and a second alternative. Once again, none of those individuals are active until something happens to you. Also, I want to talk about, there is another type of guardianship, which is Article 81, because sometimes people get confused. And this guardianship you can also do for an individual with DDID. However, this is a different process. This is a process that is lengthy and is expensive, and you do need an attorney for Article 81 guardianship, because they, as you know, the court will assign an evaluator, and you have to pay for the evaluator to kind of pinpoint the areas in which your child will need a guardian and the areas in which he or she doesn't need a guardian. So it's kind of expensive, but at the end, you end up with a tailored guardianship. That is your preference and you have the means. That's another one that you can use, but it's a totally different process and it's costly and lengthy. Okay, now reasons to pursue guardianship. Without a guardian, the individual may not receive appropriate services and their rights may be violated. Reasons to avoid is an intrusion of the personal autonomy, as JC pointed out. We have a lot of individuals with disabilities because of the practice of my Office of Disability Rights. I work with a lot of people with disabilities that certainly do not need guardians. So we need to keep that in mind. Healthcare providers may require a proof or consent, like I mentioned before. And please, I want to point out, please don't get upset with the healthcare providers. They're not doing this because they don't want to provide a service. They're doing this to protect themselves and to protect you and protect everyone else. Because remember, doctors have a license that they need to protect. They cannot go ahead and just do whatever treatment because, and then you say, oh yeah, go ahead, it's fine, he doesn't have capacity, go. And then I bet you if something goes wrong with that treatment, you're gonna try to sue that doctor. So that doctor have the right to ask for guardianship if he see a fit, because they want to protect themselves and their practice. It's nothing personal. And I say this because I have people calling me, but my child is going to the same pediatrician since he was a baby. And now he doesn't want to treatment. No, it's not like he doesn't want. He needs, you know, to protect himself, his license and his practice. So it's nothing personal. He might adore you and adore your child as a person, but business-wise, they need to protect themselves and they need to ask you for this document if it's needed. The other part, reason to avoid, the court intrudes into the life of the person and the life of the guardian, meaning they're going to ask a lot of questions about you, your child, and all that. So, I mean, if your child needs a guardian and you need to go through this, you need to do what you need to do, but keep in mind that they're going to intrude in your life and they're going to ask you questions. So this is just something for you to compare one thing to the other. I also providing you with the surrogate court location. This is important because you can only apply for guardianship in the borough in which your child with disability lives. So if your child lives with you in Queens, you're only able to apply in Queens. If you live in Queens, but your child lives in a residential facility in Staten Island, then you will need to apply in Staten Island. So this is important for that reason. Now, if you get this PowerPoint and you click in the link, it will lead you to the forms. So that's why I have those links there, because they will connect you to the actual forms. But once again, if you have any questions, any personal questions, you can email me. We can set up a time to speak, and I could provide you the links also after we talk about the information and the auctions and all that, and happy to do so. And this, the next pages are resources, links for different resources. A few that I talk about, such as supported decision making, the 529 ABLE account, all those resources are in these pages. The forms are here again. And I will say this, if you are partner of an adult with disabilities and you talk already about transition because your child is graduating, about to graduate, and you're gonna enter full-time the adult system, I will encourage you to also join one of the New York City Councils on developmental disabilities. Each borough have one. They're very active, and you will find there other parents and who are advocating for improving the life of people with disabilities, from systems to services. And you have access to the nonprofits that participate there, the government of OPWDD participate in all of them, the Office of Mental Health. So a lot of resources there and a lot of learning to do, and also a lot of things for you as a parent to benefit in order to advocate for your loved one with disabilities. They meet only once a month. It's an hour and a half. I participate in all of them as well, because I think it's important to hear from families and providers and everyone that works in the system how we as a legal office can help to improve those systems as well, because that's a goal of New York Lawyers for the Public Interest as well. More resources, and this is the end. Thank you very much, everyone who participated today. Once again, if you need the PowerPoint, you can ask me, you can email me, and I could send it to you. If you need to meet with me one-on-one, I'd be more than happy to talk to you. Just call me or email me to set an appointment, or call the main office. Once you say about future planning, guardianship, I'm the only person in the office who does this work, so they know it's me, and they will relay the message to me. So it has been a pleasure, and I don't know if there are any questions.
Thank you so much, Paola. And yes, thank you for that presentation. It's so thorough, and it goes into so many different aspects of supporting individuals with disabilities, especially as adults. I don't see any questions just yet, but you know what? Maybe we're just getting warmed up. Yes, and I will provide Paola's contact information in my follow-up email to you, so you can get directly in touch with her if you want to request the PowerPoint, or if you would like to speak with her one-on-one outside of this private forum. We completely understand that and encourage it as well. Whatever we can do to help is what's important for us. But yes, any questions at this time? I know when you were talking about supported decision making, I was getting excited too, because it was nice to see on my screen, you know, not only was it the 45th anniversary of ADA, the American with Disabilities Act, but also the governor had signed it into law. So now we just need to see what that's going to look like, because it was such an informal process, and now it is a legal process, technically. So we'll see how that looks. There's a comment here. Thank you so much. I would like to have the PowerPoint information. So thank you, Ms. Gomez. Yes, I'll provide that email address, so you can reach out to Paola directly for that. But yes, we're happy to provide that and connect you. So yes, any other questions? This recording will be available on Facebook at some point later today, I hope. It just needs to collect and all of that stuff and rebuff. But yes, that should be available, and I will share that with you in the follow-up email as well. Any other questions? See you at the end of September.
My pleasure, and thank you everyone who participated today. I wish I could see your faces, but the system doesn't allow me to do so. But once again, and for your service, and if you have any questions, concerns, please contact me. Happy to talk to anyone. Have a great day, everyone. And thank you, JC. Thank you, Synergia, for inviting me every year. It's my pleasure.
Always, always. All right, see you later.
Bye.
I'll stay on for a few minutes in case anybody has any other questions. You should be able to see the survey already activated. What is the name of the council you mentioned we can join the monthly meetings? Those are the New York City councils on developmental disabilities, and each borough has their own. So like they're also commonly referred to as the DDRO, Developmental Disabilities Regional Office. But yes, the NYC DDROs. Each borough has one. You'll also find on their website that on the Manhattan website especially, like a ton of resources. Typically each borough does their own resources, but and then they compile them. But check every borough because I know they do have work. I'm just not sure how often the other boroughs update it. But yes, but check that out because it's a really great source of information. I mean, the Manhattan region office has a guide. I think it's like 80 pages or something of resources. I mean, everything that you can imagine. So check that out. It's really good. Any other questions? Stop.